If it pleases the court, my name is Vasil Jevic and I appear on behalf of the Director of Public Prosecutions. Your Honour has been provided with the Defendant's Rule 49 notice. I will be arguing why two pieces of evidence is admissible in this matter, namely evidence from the complainant relating to the alleged behaviour by the accused towards her, and the evidence of the psychiatrist Dr. Quack. Propensity evidence is governed specifically by Section 34P of the Evidence Act 1929. The evidence provided by the complainant regarding the accused's alleged behaviour will be looked at in accordance with the application of Section 34P, where there are several discrete steps and considerations to identify the proposed use of evidence. The impermissible use identified in Section 34P1 is emphasised in R and MJJ and R and CJN, where it draws an inference of guilt from the fact that the accused has engaged in other conduct which has no relevant connection to the offence, other than to share the deficit discreditable. The test for non-propensity use is defined in Section 34P2A, which has been applied to the facts given by the complainant to identify that the evidence has a probative value that will substantially outweigh the prejudicial effect on the accused. Additionally, this test is supported through the leading case of Macon and the Attorney General, through the second principle, which states that evidence relevant to a fact and issue should be admitted if it does not fall within a recognised rule of exclusion. In R and Nitrink and subsequently in R and Mayolo, Section 34P2A has been drafted to allow for the admission of relationship evidence, provided real and legitimate relevance is established and satisfies the probative value substantially outweighing any prejudicial effect. These uncharged acts allow the complainant to put into context the relationship that was evident prior to the charged acts, where the additional occurrences with the accused conveys acts of grooming prior to the charged acts taking place. This demonstrates the probative weight of the relationship, as well as the following evidence having outweighed the prejudicial effect of the discreditable conduct. Similar as to R and MJJ, R and CJJ, the evidence provided outlines a pattern of conduct by the accused to the victim and not to people generally. Ultimately, the evidence pertains to an underlying unity which gives reasoning and connects the evidence of the offending and the evidence of this secondary conduct in a compelling way. This is prevalent through the accused's inappropriate remarks and suggestions for minimal clothing to be worn at work. This additional evidence provided about the accused recognises the impermissible use of propensity evidence. However, it surmounts to non-propensity use under Section 34P2A, where the evidence is so specific to the relationship and context of the charged acts. The psychiatric evidence provided by Dr. Quack is referred to as opinion evidence. Opinion evidence is distinguished against evidence of fact, where the role of the trier of fact is to draw inferences from the evidence presented and find the facts. Only evidence presented by a witness is from what they've actually perceived with their own senses, and where evidence is given by a witness that expresses an opinion, it is inadmissible. The admission of opinion evidence from expert witnesses has been an exception to the opinion rule and is governed by common law in South Australia. However, Clark and Ryan established two paramount preconditions for expert witnesses to qualify. The first being the subject matter of the witness's evidence and whether it constitutes a recognised area of expertise. The second precondition requires the witness to actually possess the requisite study or relevant experience in that recognised area. The test of admission is having reached the stage of either general acceptance as stated in Fry and US or sufficiently reliable in Daybert and Merrill Doe Pharmaceuticals. The subject matter has to have achieved a sufficient degree of recognised development to qualify for admission in court. Dr. Quack is a psychiatrist and paediatrician who has substantial experience in dealing with sexually abused children, specifically evidence on accommodation syndrome. Contrary to what the court held in R and F, Dr. Quack is an expert in both psychiatry and paediatrics. The psychological theory of accommodation syndrome derives from literature in psychiatry and psychology, where evidently the expert in R and F was not experienced in either field. Where Dr. Quack possesses such expertise in psychiatry, he has identified in his evidence as to how this syndrome is based on rationale and demonstrable criteria, as he will explicitly relate it to Shirley Temple. Although the court in R&F referred to the syndrome as not being a fit subject for expert opinion and identified it as a subject they do not know, regardless of whether or not the evidence comes under a recognised body of learning, it can also merge into the associated question of whether the evidence is beyond the knowledge and human experience of jury members. This simply identifies the evidence as being so special and so outside ordinary experience that the knowledge of experts about such rigorous opinion related to child sex abuse victims should be made available to courts. Dr. Quack is a recognised expert in the field of psychiatry and paediatrics with substantial experience in dealing with sexually abused children. The admission of his evidence will demonstrate his expert knowledge in accommodation syndrome and further advise the court as to its relation with Shirley Temple. Unless there are any other questions, those are my submissions, Your Honour.